creditor may assign or sell your debt to a third-party debt collection agency if you are past due on your credit card or haven't paid off a loan for a while. Once this happens, the debt collector will attempt to collect the debt. It is possible that you could be sued if you ignore the request of the debt collector to collect this debt. You may be confused about what to do after receiving a summons for a debt lawsuit. Responding is the most important thing you can do. Hello guys, welcome to my channel. In today's video, we will discuss how to make the right move when you are sued by a debt collector. Getting sued by a debt collector? Here is what happens. The timeline of the events you will be experiencing if you are sued by a debt collector is crucial to your understanding. It may vary from case to case, but in general, you will experience the steps below. 1. The debt collector contacts you or sends you a letter notifying you of debt collection. This occurs when a debt is 180 days overdue. 2. When a debt collector contacts you, he or she must send a debt validation letter within 5 days. There should be information about the debt amount, the name of the creditor, and how to dispute it if you think it is not yours. 3. It is required that you obtain a verification letter if you do not believe that you owe the debt. Within 30 days of receiving the validation notice, they must send this letter. 4. You must respond to the debt collector if you know you owe the debt. Make a plan and negotiate. You may be able to pay off the debt in full, set up a payment plan, or negotiate a settlement. 5. A debt collector will sue you if you don't pay or settle the debt. A court notice will inform you of your appearance date. 6. You will receive a default judgment if you fail to appear in court. As a result, the judge will rule in favor of the debt collector. 7. There are consequences to default judgments. As a result, your wages may be garnished, liens may be placed on your property, or your bank account may be frozen. Debt collectors generally follow a specific process, but the actual timeline varies from person to person. If you are being sued by a debt collector, you should understand how it works. To avoid a debt collection scam, you should verify the debt and the legitimacy of the debt collector if your experience does not match what's above. Find out what to do if you're sued by a debt collector. 1. You must respond to the lawsuit filed by the collector. Debt collection lawsuits must be responded to if their legitimacy has been confirmed. If this is something you want to avoid, ignoring it might seem like the best course of action. Ignoring is not an option at all. This is the worst. The collector will not drop the lawsuit if you do not respond. As a result, you will miss deadlines and have a harder time fighting your debt in the future. 2. Defend yourself against debt collectors. The majority of debt collectors are third-party agencies. The debt has changed hands more than once, regardless of whether your debt collector was hired by the original creditor after you defaulted or they purchased the debt from you. It may be worth challenging the lawsuit if the wrong person is being sued. It's a fairly common occurrence to have the wrong person's papers served on you. 2 people with the same name or multiple generations within one family with the same name can occur. There is a chance that you have already paid the debt. You could be facing a lawsuit for a debt you have already paid if debt collection agencies receive information with incorrect payment records. The debt amount is incorrect. Even if you owe the debt in question, the amount might be wrong. The statute of limitations has expired. A debt collector has a limited amount of time to collect the debt. A person's debt payment period varies by where they live and what type of debt they owe, but it usually lasts between 3 and 20 years. 3. Obtain a debt validation. A lawsuit may request that you file a response if you disagree with any information given to you in the lawsuit. In this case, you will need to ask for validation of the debt, unless they can prove the debt, where it originated, how much you owe, and to whom you owe it. It's important to bring documentation such as a validation letter if you are disputing the lawsuit, who the creditor is, whether the debt has been paid, whether the amount on the debt is accurate, whether the debt is past the statute of limitations. 4. Evidence of violations of the FDCPA should be brought. In the event that a debt collector has violated your rights, you must bring evidence of this to your trial. Consumers are protected by the Fair Debt Collection Practices Act, Fair Credit Reporting Act, and Truth in Lending Act, the FDCPA prohibits debt collectors from contact you at odd hours such as outside the hours of 8 a.m. and 9 p.m., harass you by using profanity or threatening harm, participate in unfair practices. They may threaten to take your property or deposit a post-dated check early, contact you after you have a lawyer, lies if they said they were someone else, or if they told you owed a different amount. 5. Decide whether you will accept the judgment. Accepting a debt collection lawsuit can be done in many ways. If you've accepted a judgment and are wondering how to win a debt collection lawsuit, you should consult a debt collection lawyer. Attorneys who specialize in consumer law usually offer a free consultation to discuss your options. If you need detailed legal advice, contact a licensed debt collection lawyer, as they specialize in debt defense. In spite of your inability to afford an attorney, you should ask around, as many debt collection lawyers will take your case for a low or contingent fee. In the event you accept the judgment but do not want to go to court, then you will probably have to negotiate an out-of-court settlement. Rather than going to court, you can reach some sort of settlement. The collection agency is also incentivized to do this, since the hassle and expense of going to court is also expensive for them. Threatening bankruptcy can also help if you decide to settle. The qualification for bankruptcy does not obligate you to file, but it can give you leverage when negotiating a settlement. If your wages and assets are limited, you may actually be judgment-proof. In other words, you cannot have your wages garnished. Further, if your debt is beyond your ability to manage, you can file for bankruptcy. If you file Chapter 7, all of your debts will be forgiven and the debt collector will be unable to collect from you. If you file for Chapter 13 bankruptcy, you might be able to negotiate a significantly lower amount to pay the debt collector. A debt collector cannot pursue or sue you after you pay the agreed upon amount. When dealing with debt collectors, keep these things in mind. 1. Don't accept liability. Give out as little information as possible. Legitimate debt collectors might ask for a few details to verify who you are, but you should avoid sharing too much personal information. Avoid making confessions that could be used against you in court by apologizing or explaining yourself. Furthermore, you could potentially talk yourself into a worse situation if you start rambling or apologizing after talking about a different debt. Your bank accounts should never be given to anyone. Your bank accounts should never be accessed by a debt collector. It would certainly be possible for them to debit the account and take a sum that wasn't agreed upon once they had that information, which would have adverse consequences for both parties. 3. Beware debt settlement services. When researching how to pay off your debt in collections, you may come across debt settlement companies. You should be cautious, as they may leave consumers in a worse position than when they started. In addition, debt settlement hurts your credit score. You need to understand what you are getting into if you choose to work with a debt settlement firm. A debt settlement company will charge you a fee for managing the settlement, and not all creditors will work with them. Debt management plans offered by non-profit organizations are a safer and potentially more affordable alternative to debt settlement. It is possible to work with a certified credit consultant who can help you repay your debt and negotiate with creditors to reduce or reverse fees and lower your monthly payments with this plan. Okay guys, it's been good seeing you guys. Please like and subscribe if you'd like to see more financial topics in the future. Thanks and see you in the next video.